Chair now lays out House Bill 2362 and calls on Speaker Moody to explain his bill.
Thank you, Mr. Chairman, and for my colleagues, remind Representative Bell that I was so courteous the next time he votes against one of my bills. So, or I'll let him know. It's okay. Mr. Chairman and members, I want to thank you for hearing HB 2362 today. It's a bill that reminds us of something we all know already. Sometimes we mean one thing when we pass a bill, but discover that judges think something very different.
You've been listening to our testimony all day today.
I've had an ear in this room all day, Mr. Chairman, for other reasons. Back in the 78th session, the legislature decided that medical professionals should have more legal protection when responding to emergencies. The idea was that it was one thing to expect a doctor to follow a strict standard of care with a patient they've been treating in a routine situation, but when someone who the doctor has no relationship with and no established medical history for shows up at the ER and split-second decisions have to be made, that doctor should be given some leeway when second-guessing happens in our courts. Normally, medical malpractice claims are evaluated under an ordinary negligence standard. Did the doctor deviate from the accepted standard of care? Because of the change we made all those sessions ago, liability in emergency situations requires the higher standard of willful and wanton negligence, which means the doctor not only deviated from accepted standards, but did so with complete indifference to risks that they knew existed. For those of us who aren't doctors, that's the difference between causing a car accident because you didn't see an important road sign and causing the accident because you saw the sign, knew an accident was likely to happen, if you ignored it, and you ignored it anyway. Now, I totally support that concept and think that should be the law. The question we're left with now is, what is emergency treatment? What the legislature meant for it to be was treatment of a person who presents with an emergency. Unfortunately, between a drafting issue and an active court, that's been expanded way beyond the original intent. I won't bore you with the same grammatical gymnastics our judges engaged in, but the short of it is this. In an opinion entirely focused on commas and clauses instead of public policy, our law has been interpreted to mean that only treatment in a surgical suite or emergency room has the presentment requirement. For obstetrical treatment, any emergency at any time qualifies. In the real world, that means a woman can come to a hospital to give birth, be treated by her normal OB under ordinary conditions, and even a foreseeable complication with clearly defined protocols for treatment will be evaluated at a standard so high that almost no doctor would ever be held liable, even for serious mistakes that harm or kill the baby they're there to deliver. That was never the intent of the law. So the Supreme Court knew that. Even its opinion noted and ignored statements by the bill's authors about what they meant to do. I also sat down with Senator Duncan, who I think is here, just last week to ask what the legislature meant when it crafted these standards. Everyone agreed the goal was to never do what the court did. It was for the doctors to have a bigger shield when patients come to them in an emergency through the emergency room. The ledge in this case simply forgot a comma. I know that some groups that are benefiting from the mistake want to keep that law unchanged, but that shouldn't be how law is made. When we're talking about a statute, that law is made here in this building and not in a courtroom. My bill moves this law back towards the original intent by making sure obstetrical care is properly covered and clearly defining what a non-emergency situation is. Now, with that being said, I fully anticipate coming to you with a new version of this bill. We've been working with stakeholders to get some language. There's some that there'll be relative comfort around, such as perhaps adding a foreseeability requirement so that the truly bizarre circumstances no one could have predicted they would also get the heightened protection. So I will not ask you to certainly wouldn't ask you to take any action on this until we come to you with that substitute, but is not before you today. Whatever we do, though, some kind of fix is needed here. That much is clear. With that, I'm happy to answer any questions. I know there are others behind me that were in those stakeholder meetings as well, and I think can probably enlighten you much more than I can, as I am a criminal law practitioner and not a civil law practitioner.
Thank you, Speaker Moody, for the bill and for the layout. Members, are there any questions? Okay. You're recognized for your reserving your right to close.
Thank you, sir.
We've got Let's do two panels of witnesses here. Senator Duncan, come on up, and then also Sam Roberts, Heather Owen, and Craig Island. Ms. Owen, let's start with you.
Thank you.
And if you'll just state your name and your affiliation, your position on the bill.
Yes, thank you very much. My name is Dr. Heather Owen. I'm an emergency medicine physician representing the Texas College of Emergency Physicians. And on behalf of the members of TCEP, I testify today in opposition of House Bill 2362 as filed. For the past 10 years, I've provided emergency care in the DFW Metroplex, initially at small hospitals in Allen and Rockwall, and now I'm currently full-time at Texas Health Presbyterian Hospital in Dallas. Presbyterian is a level 2 trauma center and a comprehensive stroke center. Emergency medicine physicians work in a unique environment. We see patients in distress situations, the sickest of the sick, often unable to communicate with us effectively. We must make split-second decisions, often working with limited information on the patient's actual condition, their health history, and the medications that they take. Past legislators have wisely recognized these limitations and have rightfully carved out liability protection specifically for those engaging in emergency care. We do the very best that we can, often given limited time and resources. As mentioned, emergency physicians stand together to oppose House Bill 2362 as filed. This bill asks you to remove willful and wanton protection when a patient arrives in a stable condition and then moves from stable to unstable in the emergency care setting. But when exactly does a patient move from stable to a state of emergency? The wellness of our patients fluctuates vastly in the time that we care for them. It's a continuum. There's no clear line of demarcation. Let's consider this in practice. An elderly man, let's say your father, presents to my emergency room with several days of illness. He has a high heart rate, he has low blood pressure, he has 103-degree fever. His body is becoming overwhelmed with infection, he is septic. He needs to be aggressively treated with intravenous fluids and strong antibiotics. His vital signs improve, so he's temporarily been stabilized. However, his blood vessels are leaky. After receiving those fluids to treat his low blood pressure, he consequently accumulates fluid in his lungs, and now he becomes unstable and starts having trouble breathing and needs to be intubated, a tube put in to breathe for him. Was any part of his emergency caused by that need for IV fluids? What were my alternatives? I give him the fluids because he needs those fluids to save his kidneys, his liver, his brain. But then I risk the fluid in his lungs. This is a known complication of sepsis treatment, but technically, am I causing him harm? We're doing everything we can to make this patient better, yet House Bill 2362 would punish us for pursuing any treatment option that has inherent risk. In the emergency department, we're continually weighing risks, benefits, alternatives. Under House Bill 2362, any decision we make in the ED will be used against us as if we had full knowledge of the patient's condition and how they theoretically would have responded to treatment, all in retrospect. On my shift yesterday, I had a 52-year-old female who came into the emergency department with sudden onset left-sided weakness. Very quickly I identified that she was suffering from an ischemic stroke. This occurs when a blood vessel carrying blood to the brain is blocked by a blood clot. Her symptoms were debilitating. They would clearly prevent her from taking care of herself in the future. My training and expertise tell me her best chance to regain function and live an independent life is to give her TPA. That's a powerful clot-busting medication used to dissolve clots and restore blood flow. But administering TPA comes with significant risk.
Miss Owen, hey, if you can get to a stopping point, that it's
Yeah, Judge.
no,
No,
actually, time. You're fine.
Dr. Owen, I'd love to hear what else you have to say.
Yeah,
It'd be
okay.
great. Dr.
I
Owen is a
appreciate
constituent of mine.
That-
so I'd
no,
love for
thank
her
you.
her to finish that out. So however much time you need, Dr. Owen, you've got it.
Let me be clear. I'm trying to be consistent with all the
Correct.
witnesses.
No, thank you,
but
Mr.
you
Chairman.
asking questions gives her as much time as she wants. Take
Thank
it
you, Mr.
all.
Chairman.
Thank you.
I've got just a short.
Nope, take your time.
45
Chairman Meyer
seconds,
gets
I'm
what he
sorry.
wants. Go ahead.
Thank you. So anyway, I need to give her TPA. So this drug can potentially restore her function, but can also worsen her condition. So in 100 patients that we treat with TPA, 33% of them are going to get better, but 5% are going to get worse. Thus, the doctors must weigh the potential benefit against the small but foreseeable chance of a major side effect. We must make these decisions in a matter of minutes, whether or not we should take that risk. And if I'm no longer protected to do what is in the best interest of my patient, despite the inherent dangers, will I still feel comfortable making those high-risk decisions in that short period of time that I have? Our state has seen significant growth in the number of ER physicians since the passage of the 2003 reforms and the heightened willful and wanton emergency care standard. Texas is known as a state where doctors can come practice good medicine, as they're clinically trained to do, without the fear of being sued unjustly. House Bill 2362 runs counter to that axiom and will produce unintended consequences. It will limit our ability to attract and retain quality emergency care physicians, invite misguided litigation, and discourage doctors from taking the necessary risk which is often required in the treatment of patients presenting with a serious or a critical illness. I urge you to vote no on House Bill 2362. I thank you for your time, and I'd be happy to answer any of your questions.
Thank you. Members, any questions? Chairman Meyer.
Dr. Arnold, I just want to thank you again for being here. We understand you took time out of your practice to be here and appreciate you doing so. And also I understand you've had an opportunity to speak with Speaker Moody, and I know he looks forward to and was very kind to take the time, looks forward to working with you and others to make this bill not only effective to get what we need to get done, but also practical for those practicing physicians. So thank you for being here.
My pleasure
Appreciate
to be
it.
here.
Thank you, Chairman Meyer. Members, any other questions? Thank you, Doctor. Appreciate you being here. Senator Duncan, if you'll state your name, your affiliation, your position on the bill.
Thank you, Mr. Chairman. Robert Duncan. I am here on behalf of myself and am speaking on the bill. In 2003, I was on the conference committee for House Bill 4. Many of you may remember House Bill 4 was a very comprehensive tort reform bill, probably one of the most in the country. Dealt with a lot of different issues, products liability, healthcare liability, just various very large bill with a lot of complex changes in policy. There were a lot of negotiations. However, I don't think the bill was an agreed to bill by all the stakeholders as it went forward. At the end of the day, both houses, the Senate and the House, both tried to deal with these emergency situations in different ways. At the end of the day, in the conference committee, the provision of the statute that's in question was put into the bill during the conference committee process. And during that process, apparently the Supreme Court disagreed with the language. But what was intended was clearly stated by the chairman of the committee at the time and the author of the bill, Senator Ratliff. And relevant to what we're talking about today, Senator Ratliff asserted that, and I'm just reading from the footnote in the footnote 14 of the opinion, this section does not apply to emergencies that arise during surgery or labor and delivery, and instead applies only to emergencies that exist when the patient is brought into the ER and still exist when the patient goes immediately to the OB unit or surgical unit from the ER. That was the intent, that was the representation that was made to the members of the legislature when this bill was passed. Now, the difference between the case that is in question and that raised the issue of the ambiguity or unambiguity as the court held of this statute is a lady who presented to the OB department for a induction the night before, was in stable condition, and had a complication during labor and delivery that was called shoulder dystocia. Clearly, with the intent of the language that was represented to the members of this body when we voted for it, that language, or rather that situation, would not apply under the provision, under the intent of the legislation as stated by Senator Ratliff. The reason that I'm here is that these types of legislative enactments require a lot of trust and require a lot of they're very complex, and as we go through the process, we make representations to members to get the votes to be able to pass the legislation. And when we have something that goes beyond what we intended, as I believe in this case happened, then it's incumbent upon us to get the policy correct. Now, it allows us to revisit this policy, to take into consideration things that have been raised as we've gone forward or we've learned since 2003. But at the end of the day, I think the original intent of the policy was good. I think Speaker Speaker Moody has accurately represented what this legislation is intended to do, and I think where the policy is going forward, that we can, so that we can reach some sort of an agreement or some sort of language that gets us to a place that reflects that intent that was passed by the legislature in 2003, and has a clear statute that everyone can accurately rely upon.
Thank you, Senator. Members, any questions? Thanks. Yeah, really good to see you. Congrats to your Red Raiders.
All right, thank you.
The chair calls Craig Island.
Go ahead. Thank you, Mr. Chairman. Craig Island, here individually and as a former member, testifying on the legislative intent of the bill and for the bill. And what I've passed out to you members is I too, along with Senator Duncan, was here for this bill, and I pass out to you the legislative intent from Joe Nixon and I on the House mic. And this is the intent that was ignored by the Supreme Court, because they don't look at intent unless they say that there's a statutory ambiguity in the language. And they said, there is no ambiguity, so we're not going to look at the legislative intent. So I just ask that you look at the statements of the legislative intent when we pass the bill, and it applies to this exact specific situation. Because I asked a question of something that happened to my daughter and asked how it would be applied under this bill. And my questions were asking about the bill. Says a woman goes into the hospital, preterm contractions, and her physician's not there, but whoever the physician has on call for his or her group, sees the lady and says that she's hospitalized and stabilized, but later the baby's heart rate drops because a cord is wrapped around her neck, and they say we have to do an emergency C-section right now. Under the bill, would that situation arise under the higher standard? And Representative Nixon, the chairman, who it was his bill in the House, no, it's the intent of the legislature that emergency situations where you do not have a prior relationship with the patient is the one given the protection, the higher standard. If you have a prior relationship with the patient and you know about their medical history and their background, you should not be given the protection to the same extent as someone who just shows up at the emergency room. You have no history, you have to treat them. That's why we have a different standard of care. And then finally, if an emergency arises while you're at the hospital, Chairman Nixon, that's right. If you create the emergency, you don't get the protection either. And so I think when Mr. Harvey, who will testify in a minute, tells you about the case here, it falls into that exact pattern, that exact scenario, which we thought was very clear on the legislative intent, but because apparently the court says that the statute is unambiguous, they don't look at the legislative intent and came to an exact opposite conclusion. So when you see people get up at the back mic this session and talk about legislative intent, if we don't pass Speaker Moody's bill, then that legislative intent means nothing for now and forever. Because I think the legislative intent in both the House and the Senate is absolutely clear of when that higher standard is supposed to apply and when it's not.
Okay. Thank you, Craig. Members, any questions? Okay. Let's see. Is it Mr. Jackson? No.
Roberts.
Mr. Roberts, that's right. Mr. Roberts, yeah, if you'll state your name with and your affiliation. I've got you here on behalf of yourself and U.S. Acute Care Solutions.
Correct.
Registered against the bill?
Yes.
Okay, go ahead.
Yeah. I'm Sam Roberts. I'm an emergency physician. I've been practicing here in Texas for nearly 40 years now. I speak in opposition to House Bill 2362. In addition to seeing patients, I also serve as the Chief Medical Officer for my organization. And so I've been very gratified actually for the original bill, Senator Duncan, and I'm happy to testify today to try to clarify anything here. One of the things I've seen is we've seen an incredible opening up of the Texas borders to physicians since this bill passed, particularly emergency physicians. That's That's my area. And we're getting, it's a mecca for people to come to. We're getting the best and the brightest. We used to have a terrible physician shortage. It's gotten much, much better. We've still got a little ways to go, but we're doing much better. So I'm very gratified for what's happened so far. As Heather mentioned, we're there to try to help people in their worst times. Nobody wants to see my face. You don't come into the ER because you're happy to be there. You come because you're having the worst day you ever had, in many cases. You have to understand that the rendering of emergency care is very complex, and it's been referenced. I think I'm not going to beat it up, but it requires split-second decisions with very little information sometimes. More often than not, when we have bad events occur, it's because there's an emergency in process, even though it may not have been recognized. The stable issue is one of the things that I have a problem with, because that is something that requires, that will be argued if somebody is stable or not. That is a very difficult thing to define. We have to deal with diagnostic uncertainty, and it's not because emergency physicians are not good doctors, but the very complexity of the things that we see make it very difficult. A lot of times a patient comes in thinking they have one thing, and they'll tell us exactly what they are experiencing. And sometimes they've already decided what they've got. They've looked it up on the internet, but they're wrong. And we have to tease out what's really going on. For instance, a patient may come in complaining of shoulder pain. Their arthritis is acting up. They'll tell you that. That's what they told the triage nurse. But after more investigation, it turns out that we've got to consider other things like a heart attack, like a dissecting aneurysm, which is a tear in the major artery coming out of the heart. Someone might think that person came in stable condition, and if somebody hadn't actually teased out what's really going on with them and found out the final diagnosis, a shoulder arthritis is not an emergency, and I think you would all think that's stable. In addition, we're under increasing pressure, as many medical professionals are, to try to control the cost of health care. Many of us, myself included, have high deductible policies, so I'm paying the first $3,000 out of my pocket no matter what. So we're asked by patients, don't waste my money. I always try to do things in a cost-efficient manner, but I think that if this bill passes in its current form, it's going to increase the cost of care by making people either admit people who don't need to be admitted or do unnecessary tests.
Okay, thank you, Dr. Roberts. Members, are there any questions? Yeah, Representative Krause.
Chairman, more of a comment. Drs. Owen and Roberts, I just have a ton of respect for what y'all do. I can't imagine what y'all see day in and day out and being able to react and respond to those things and how you take care of folks. So I just wanted to thank you again for the work y'all do day in and day out, taking your time to come down here and testify tonight as well. But thank you for the work y'all do.
Yeah. Thank you. Members, any questions? Okay, thank you. Thank you to the panel. We've got 3 other individuals who've registered to testify. The chair calls Jay Harvey, Brian Jackson, and Raymond Hampton. Mr. Harvey, we're going to start with you. If you'll state your name and affiliation and position on the bill.
Thank you, Mr. Chairman. I'm Jay Harvey. I'm here individually and on behalf of Texas Trial Lawyers Association, testifying in favor of the bill. First thing I want to do is address the issues that came up in the Wilson case, or we sometimes refer to as Presbyterian. The patient reported to the hospital the night before for a planned induction for delivery, and sometime the next day, hours later, after an uneventful labor, the delivery proceeded as normal until at the end the shoulder became lodged. It's called shoulder dystocia. The doctor performed various maneuvers to try to free the shoulder, resulting in the delivery with the child having a very severe injury, usually called Erb's palsy. And the family brought a lawsuit based upon the fact that the doctor failed to use the correct maneuvers in freeing the shoulder. That was what the base of the lawsuit about. This was her ongoing obstetrician that she had been seeing there in the hospital that she'd been in since the night before. So the court was asked to address, in order to get willful and wanton, does the patient have to go to the ER and then to the OB? And as Senator Duncan said, the predominance of this opinion addresses where was the comma? Where was the comma? This bill doesn't address that. When we first talked to Speaker Moody, it was never our intent nor anybody else's intent to try to change that concept that willful and wanton standard can go when the patient reports directly to the OB without having to go through the OR. And that was the issue, the sole issue before the court. However, and in the pamphlet that I have laid out for you, there are 2 tabs on the opinion, which is behind number 5. One of them shows the conclusion, and you can read from the conclusion that the court not only concluded that you don't have to go through the ER, but you can go directly to the OB, which I understand that, but the court went well beyond that said any emergency that subsequently arises in the OB unit gets willful and wanton standard. So you've heard from Senator Duncan and you've heard from Representative Island that is specifically the opposite of what was intended when this bill passed in 2003. It was never the intent. Now, here's how we can know that's the case. When you look behind tab 2 on the pamphlet, it defines emergency medical care, and it has 2 exceptions. 2 things that are not emergency medical care. That includes care that occurs after the patient has been stabilized, and if the care that is in question is unrelated to the original emergency. To address the physician's complaint was, how do you determine stabilization? That's what juries do. They determine that based upon on the evidence. So this is already in the statute about you don't get willful and wanton after the patient is stabilized. You don't get it if the emergency occurs and it's unrelated. What the bill does, it adds basically 2 more sections. One, if the patient comes to the emergency room or to the OB not in an emergency, not needing emergency medical care, but needing medical care, you wouldn't get willful and wanton. Or if the physician or the nurse, the healthcare provider, caused it. So under tab 3, it outlines where the standard is, but tab 4, it provides for what jury instructions are. And I know this is kind of down in the weeds, but I hope you'll indulge me. But when you look at what 74-154 says is, if certain things occur, Section A, which is the jury instructions, don't apply. Those are things like if the care occurs after stabilization, if it's unrelated, or if it's caused by the defendant. What sense does it make that those would affect whether or not jury instructions are given? Those should, in fact, direct whether or not it's a willful and wanton standard. So what Speaker Moody's bill does, it takes those things from the jury instructions section, 154, and moves them to 153, to the substantive section, and adds that if the patient comes in not in an emergency. This is not to change the standard of care. This is not, I don't care what anybody says, this does not do away with willful and wanton. This does not. Willful and wanton applies in the face of an emergency, and it continues to apply in the face of an emergency. But when there is stabilization, or when there is a non-emergency, when emergency medical care doesn't apply, it's not willful and wanton. This bill achieves just exactly what Senator Duncan, Representative Island said was the intent in 2003.
Thank you, Mr. Harvey, for your testimony. Members' questions, Chairman Meyer.
Sure. So we heard the physician's concern about stable and how you define it. I mean, I appreciate you're an attorney like I am. I don't know and couldn't even get close to defining it. So how are you saying that you can absolutely get stable when I've got a couple of physicians telling me who this is what they do for a living? That it would be really, really hard to define that term.
It is hard to define that term.
Okay.
I don't dispute that.
Okay.
However, the way it works is, and it's been in existence since 2003, there's been a key fact of this area of the law since 2003. From the early on in the pattern jury charge, we have an issue on stabilization. And so it's determined by, I will bring my expert witnesses in to say the patient is stabilized and here's the criteria, and they say why. Maybe the defense brings in expert witnesses, say the patient wasn't stabilized and this is why. And so we call it, that is a jury question to be determined. It's not something that just the lawyer or the judge, but the jury decides that based upon the evidence, not just that somebody makes a conclusory statement.
Right, but I think they were saying as well, in an emergency situation, it's a little harder to define what is stable. Do you disagree with that premise?
I don't, and that's why,
Okay.
and the very definition judges their conduct under the same or similar circumstances. To try to say this is all Monday morning quarterback, it's not. This is the very definition of negligence is under the same or similar circumstances. And so when I present, if I do, an ER physician to testify, that ER physician understands split decision making is split second decision making. And so that's a different concept. It is under the circumstances. So this is not to do away with that. This isn't to cut back on the number of ERs. This is to say, if you're not in an emergency situation, don't get this extended protection.
I know, but I think we do need to listen to the physicians and understand that the job that they're doing is quite different than what the rest of us do, and therefore we need to make sure that protections in this bill to make sure they are in fact protected in these unique circumstances. So, and I'm not saying you're testifying differently. I just wanted to make sure that was clear.
And that's why I think the definition that was adopted in 2003 provides that, is if the care is provided. I mean, this is an existing law. If the care is provided after stabilization, it's not willful and wanton. So that is the threshold question that has to be decided in any of these cases firsthand.
Understood. Thank you.
Members, any other questions? All right, thank you, Mr. Harvey. The chair calls on Brian Jackson. You state your name, your affiliation, your position on the bill.
Yes, my name is Brian Jackson, and I serve as General Counsel for the Texas Alliance for Patient Access, also known as TAPA. I'm testifying against the bill. TAPA is an organization of over 250 healthcare interests in Texas, including the Texas Medical Association, the Texas Hospital Association, nursing homes, hospitals, charity clinics, specialty medical societies, and liability carriers. In 2003, the state of Texas had a healthcare liability crisis, and the Texas legislature passed what is now Chapter 74 of the Civil Practice and Remedies Code to address that crisis, and they successfully did so. At the time, in 2003, doctors couldn't afford their malpractice premiums. Hospitals had to curtail services in order to try and pay additional premiums. Hospitals had a hard time finding physicians to staff emergency rooms, a hard time to find physicians to deliver babies in their areas, especially in rural Texas, where I spend a lot of my practice. They did not have people in the emergency rooms. The bill that was passed in 2003 was successful, and it did address that crisis. And now we have more physicians in Texas than we have ever had. We are very, very concerned and know that House Bill 2362 will definitely take us a big step backwards towards 2003. The specific language in 2362 states that if any part of the emergency was caused in all or in part, then willful and wanton is stripped for all defendants. That means every case is going to turn into an academic argument 18 months after the care was rendered with an expert witness out of California that finds some sliver of problem that a nurse may or may not have done or a doctor did. If it contributed 1% to that emergency, every defendant loses willful and wanton. On top of that, all of those healthcare providers that come running to the room after the emergency takes place, they come in to help, to try and help somebody, they lose willful and wanton as well. They don't have the willful and wanton standard either. So the all or in part contribution will be devastating to healthcare providers that participate in emergency care. Additionally, the whole stable argument is a very, very dangerous path in our opinion, because patients that are stable, well, of course, your care is judged on the regular negligent standard. But once they go into an emergency, you still have the same number of seconds to determine what to do. If they have the emergency in the parking lot, you get willful and wanton. But if they have the emergency room after they come in and get checked in and then have the emergency, well, you don't get willful and wanton. That doesn't make any sense. They were stable, and so you don't get willful and wanton. And more importantly, all of those that also come running into the room to help, they also lose willful and wanton. I don't think any of us want healthcare providers, as they run down the hall to an emergency, wondering to themselves, I wonder if I have willful and wanton. I wonder if this patient was stable. We all know they'll still come running down the hall. They'll still come to help. The question will be, will they volunteer for call? Will they let you sign them up for call? Will they cover those particular areas if they know that they will have increased exposure? We do know that in 2003, they wouldn't, and they didn't. They helped when they were there, but they didn't sign up to help because of the exposure that they were subjected to. So we are opposed to the bill. I certainly understand and respect Senator Duncan and the legislative intent that he has cited as to what was there. That's been 16 years. 16 years have passed since that legislative intent was there. I believe, and my organization believes, that it is more important to evaluate the present circumstance as to what exists in healthcare, what has worked, what did work, and make a decision about what's best for patients, what's best for healthcare providers, versus what was said 16 years ago.
Thank you.
Thank you.
Thank you, Mr. Jackson. Members, any questions? All right, Chair seeing none. The Chair now calls on our final witness, Raymond Hampton. Dr. Hampton, if you'll state your name, your affiliation, your position on the bill.
Thank you, Chairman Leach, and good evening to you and to the committee members. My name is Dr. Moss Hampton. I'm an obstetrician gynecologist with 38 years of experience. I recently retired from Texas Tech University Health Sciences Center of the Permian Basin, where I was the chairman of the OBGYN department. Today I'm speaking against the bill and speaking on behalf of the Texas Medical Association and the American College of Obstetricians and Gynecologists, District 11, which is the state of Texas. As has been stated, we feel that this bill could have grave consequences for obstetricians and gynecologists in the state of Texas and would have a very detrimental effect on women's health in a more broad position. As I think people are learning, things in obstetrics can change dramatically and can change quite quickly. This simple, uncomplicated pregnancy that we've been talking about can rapidly become a frightening medical and/or surgical emergency for the mother, the fetus, and the physician. For example, it is almost impossible to predict an amniotic fluid embolus. You can have a normal pregnancy, a normal labor, a normal delivery, and then have an amniotic fluid embolus and be dead in less than 5 minutes. So you go from this stable condition that we've talked about to a extreme emergency in light speed. The same thing could be true with the pulmonary embolus. The same thing could be true with the postpartum hemorrhage. So this definition of what's stable and what's an emergency becomes very concerning to us. The heightened willful and wanton protections under the proposed law would not apply to any of the rescuing physicians or nurses that would intervene in treating such an emergency. And we feel that doctors and nurses should not be held liable for an emergency that they did not cause, but they are responding to, even though the patient was, quote, stable only a short time beforehand. We feel that the changes in the law would discourage obstetricians and other high-risk specialists, such as maternal fetal medicine physicians, anesthesiologists, trauma surgeons, critical care intensivists, from coming to Texas. And as has been mentioned, with the changes in the law in 2003, we have seen a dramatic increase in the number of physicians wanting to come to Texas and practice in our environment. As mentioned, we do have a shortage of certain physician specialties in certain areas of the state. We feel like this legislation would have a detrimental effect, particularly in our small and rural communities, where we know that women already have problems with access to care. So in summary, we feel that House Bill 2362 creates a dangerous and hostile environment for physicians at a time when Texas is in desperate need for them. This bill runs the risk of preventing doctors from providing a patient with the best possible care, especially when they are concerned that their actions may be subject to litigation and put them at further risk. We ask that you vote no on House Bill 2362, and thank you for allowing me to testify today.
Thank you, Doctor. Members, any questions? Okay, thanks to each of you. Appreciate you being here. Thanks for your patience today. Does anyone else wish to testify on, for, or against House Bill 2362? The chair, seeing none, the chair recognizes Speaker Moody to close on his bill.
Thank you, Mr. Chairman, members. And I apologize for having to step out, so I didn't catch everything. But did want to visit on a couple things. We're continuing to talk with all stakeholders like we did last week. Certainly, without a fix, there's a potential for someone to be at the root cause of an emergency and get a higher standard of proof applied to them. That absolutely cannot be where we end up at the end of this session if they're involved in causing the emergency. And so we have to get somewhere on that. Look, we all don't know how much time we have here, and we talk a lot about the intent that we have behind laws, and I can't say it any better than the senator and representative did earlier. We work very hard on these things, and the courts may dismiss what we do whenever they want to, but this body, I think, holds very near and dear the value of legislative intent. We know why we're here and what we're doing, and the two folks that came up here before certainly had that clear 16 years ago. And I know 16 years is a long time, but this case that we talked about is the only case on this provision, and it is new. And so when we say 16 years, there's 16 years of jurisprudence around this law, but this piece, this is the first time that we'd have the opportunity to look at what the court did to it. And I think had the court taken the time, like they should have, rather than ignoring it, I think we'd be in a different place. So I do also want to mention a lot of the circumstances that were brought up by some witnesses about, well, now I got to worry about this or I got to worry about that, or if it's not really what the effect of the situation is. It is the standard of care. And so I would argue that the situations that were described here to you, even under a basic negligence standard, that doctor would be just fine because she did nothing wrong. And so, I think we should be careful about hitting the panic button. What happened in this case was that some folks that did not have this protection now have this protection. And when you get something in this world, you tend to not want to give it up. But that was never the intent of this. And we're going to leave some folks out that are harmed that were never meant to be out. And so I will be diligent in my work to bring you back something that brings folks together on this issue. Because I don't think we can walk away from here in May without fixing something around this area. There are situations that I don't think those physicians would want covered with a higher standard either. And I want to make sure that we address that if we can. With that, I'll take any questions and I'll close.
Yeah, Speaker Moody, thank you. Thank you for your testimony. Members, any questions for Speaker Moody? Okay, with that, the chair will leave House Bill 2362 pending, and thank you for your patience today. Members, we're going to take up 3 bills as pending business, and then we're going to call Representative Sanford up to lay out how